Mr. Fantera, if you, the court will call the case of the Ranches of Rosebrook versus Anise Battle, case number 25C-1245.
Good morning, Your Honor. David Fantera on behalf of the plaintiff.
Battle, please unmute and state your name.
Anise Battle, appearing especially, not generally.
Thank you. All right, we're here for the continuation of the hearing today. Battle, when you're not speaking, please.
You said, can I mute my mic when I'm not speaking?
Correct. Thank you. All right, Mr. Fantera, I believe that we are in the middle of your, well, actually, it was Ms. Battle's direct.
Yeah, I think Ms. Battle was cross-examining Ms. Charles.
That's correct. Ms. Battle, are you ready to proceed?
Yes. So, Don, do you have a signed lease between me and you in this case?
Yes.
Did I ever waive my rights or agree to the terms in writing?
What's the question?
Did I ever waive any of my rights or agree to your terms in writing?
Your Honor, I object. I have no idea what that means.
Meaning that there are waivers inside of the lease.
Your Honor, she's got a signed lease. That lease was, we moved to have that admitted last time, and it was admitted. Ms. Battle did not object. So I don't know what she's asking right now when she talks about a waiver. She signed the lease.
Okay, that's fine. Are you aware of the notice of rescission that was sent?
Yes.
Your Honor, I object. Rescission, we can't go down this road again.
Why are we not going down the road?
Let him finish his objection, please.
Okay.
Your Honor, this case is not about rescission. It's about, this is a non-payment of rent, pay and stay case. The question is, how much money does she owe in order to stay in her lease? She believes, and she stated, and she was overruled by Judge Vandenberg, and I believe by you, that her belief that she rescinded her lease and therefore she gets to stay until she finds a new place is not the law, and she should not be allowed to pursue that line of questioning. This is not about rescission, which, by the way, she hasn't done anyway.
All right. So your argument is that her question is not a legal question and therefore you object.
It's not based upon law.
It is based upon, what law is it not based upon? It's based upon common law. You have not proven or stated any laws or facts that back what you're saying. Unlike me, I have.
Yeah, but you stated them all wrong. And one of the things you stated was the Magna Carta, which was from the 12th century in England.
No, I stated it under common law and landlord-tenant acts.
That's not, we're not under common law anymore, ma'am. And that's a part of the problem with sovereign citizens. They think they know the law when they don't. That is not.
Well, that sounds crazy.
All right, folks, buckle up because today's courtroom showdown is an absolute wild ride. We've got a crayon-eating, so-called sovereign citizen, Karen, trying to school the court while Judge Washington isn't holding back one bit. From claiming mental health issues to insisting she can make up laws as she goes. This case already screams chaos. Today, the kids aren't in school, but the stakes are just as high because now it's her mother's turn to get schooled. Expect legal missteps, fiery objections, and some of the sharpest roast you've ever heard in a courtroom. Stay tuned, because things are about to get intense.
Under MCL and it's under the Landlord-Tenant Act.
Overruled.
My objection is overruled, Your Honor?
No, the objection is sustained. Her question that cannot be asked.
So you're saying I can't ask about the contract that's in question?
No, I'm saying that you have no basis for asking whether the contract was rescinded or not.
Why would I not have basis for asking if the contract was rescinded?
That's not the law. You don't get to unilaterally rescind anything, ma'am.
Well, again, as I stated,
my ruling, I'm not arguing with you anymore about it.
Right. It's not an argument. So just let the record show that there is no law or basis to what she's saying. And she has not yet stated any law or fact behind this objection to asking these questions. I will continue. Okay. Did you write me a notice to quit filing this action?
A notice to quit?
Yes.
No.
I think she's referring to a demand for possession,
A
Dawn.
demand for possession, yes.
No, a notice.
Asterisk, here's where it gets juicy. Miss Battle starts questioning the lease and waivers, acting like she's got a secret ace up her sleeve. But the lawyer is visibly frustrated. She signed the lease, she didn't rescind it. And that's the legal reality. Judge Washington doesn't even need to lift a finger. The law speaks for itself. And let's be honest, the commentator's duck analogy is hilarious but painfully accurate. This is exactly the kind of overconfident, misguided legal logic courts see with these sovereign citizen-type arguments. Drama is high, egos collide, and you can almost feel the tension crackling through the screen.
To quit.
No.
Right. Do you have proof of delivery or service of any notice to quit?
No, I didn't send one.
Right. Are you aware that MCL 657-16 requires a notice to quit before initiating an eviction?
Your Honor, I object. Miss Battle is confusing the term notice to quit with demand for possession. A notice to quit is how you start a termination of tenancy case. This case was started with a demand for possession. If Miss Battle wants to use the wrong term, she's going to get the wrong answer. The statute says that we can start a non-payment of rent case with a demand for possession, and that was issued. And if she asked that question, Ms. Charles can answer that question.
Is there proof of service? Is there proof of delivery on that demand for possession?
Miss Battle, can you do me a favor, please, ma'am?
Yeah.
Give me one moment. You cited a statute that I actually need to look up. MCL what?
I'm sorry?
What was the statute that you cited?
MCL 657.6.
Next, Miss Battle tries the classic constructive eviction argument. The property is unlivable, so she shouldn't pay rent. The problem? She's still living there. Judge Washington and the attorney are having none of it, and every objection she makes just gets shot down. It's a textbook lesson in how staying in a property nullifies claims of unlivable conditions. And yes, we get more of that savage duck analogy, because honestly, if it quacks like a duck, courts aren't going to entertain it. Audience, here's a fun question. Have you ever seen someone argue so passionately but totally miss the point? That's courtroom drama at its...
Yes, I had read it when I first did this.
It uses the term demand for possession.
Okay, everybody please stop typing. It says, a demand for possession or payment shall be in writing addressed to the person in possession and shall give the address or other brief description of the premises. It's a demand for possession, not a notice to quit.
Okay, so is there proof of service of it on the record?
That's a different question though. So, okay, go ahead.
But that's the question I asked next. Once he said that the
But I
demand for
wanted to
possession.
clarify your question before.
I appreciate it.
All right, Ms. Charles, please add her question next is there proof?
Do you have a proof of delivery or service for that demand for possession?
Nope.
Nope. Did you know that under MCL that you're required to have a certificate of service or proof of service on the record?
Your Honor, I object. She's now, again, she's not using the statute changed 10 years ago so that you now need on a demand for possession a certificate of service. And that's what's at the bottom of the page. If she's looking for a proof of service, meaning somebody going to the door, she's going to get the wrong answer again. The term is certificate of service, and I believe Ms. Charles will answer that question differently because there is a certificate of service at the bottom.
Now we hit the legal nitty-gritty. Miss Battle insists there was no notice to quit. But here's the kicker. Under Michigan law, landlords can initiate eviction with a demand for possession, not a notice to quit. The lawyer patiently sets her straight, explaining proof of service and certificate of service requirements. It's a brilliant teachable moment. Using incorrect terminology can completely derail a case. And the commentator adds a pinch of humor. Don't do drugs, kids, because apparently it makes you forget what you just said 2 minutes ago.
So
You,
can I make my ruling?
like, let's just, okay. All I'm trying to do is ask questions to make sure certain things are on the record. A certificate of service
Okay,
is
ask that
is
question.
not on the disposition. And just like she read on 657 16, was the property described on that disposition?
Yes.
Was there a description of the property?
Yes.
If there was a description of the property?
Correct.
On my copy, there is no description of the property. But let's continue. Does your company participate in HUD programs or accept federal HUD assistance?
Yes.
Okay. Did you provide me with grievance procedures required by HUD?
Did I provide you with what?
Grievance procedures required by HUD.
Your
No.
Honor, I object. That's irrelevant. There are no
It's
such grievance procedures under this anything that I'm aware of. I mean, I don't even know what she has a grievance about.
right. The grievance would be with the breach, and you all have a grievance, and hence on why you initiated a hearing for the breach of the contract. So it goes back to HUD because you're publicly funded, right?
No, we're not.
And-
No,
publicly-
we're not publicly.
Well, you accept HUD housing. You accept HUD housing and you apply, and you are in compliance with HUD laws and policies, correct?
Yes.
Right. Okay. So if you have HUD terms and you're
Your Honor, I object. Miss Battle is taking.
object to it, I didn't say anything yet.
Well, I'm objecting because she asked Miss Charles a question, which was, do you get any funding from HUD? Yeah, most companies do. We do. And then she takes that and starts taking that to a next question where it says, well, when you get funding from HUD, and then she's assuming.
I didn't assume anything. I asked the question.
Okay, what was the question you were going to ask?
I said, do you have to follow HUD's policies? That was my next
And
question.
she said yes.
Right. And then you objected after that.
No, and then you started the next question.
No, I started the question, but I didn't get it out my mouth
Everybody,
before you
please
objected
just
me.
let her ask the next question, and if you have an objection, I can hear it after she finishes her question.
Okay.
Okay. Are you aware that before you initiate a hearing in court or the administrative process before court, you have to have an administrative hearing by a HUD administrative judge?
Your Honor, I object. I'm not aware of any.
Say no. I mean, that's
Just
not.
say no because you're not aware, and that's okay to not be aware. That just means that you are not aware of the laws that govern.
No, it doesn't,
It-
because
it-
it's not, that is not the law, ma'am.
How is it? Okay.
You're making.
Are you aware of the requirement under 42 USC 1437 DK for federally?
Miss Battle pushes forward, asking if there's proof of service for the demand of possession. The lawyer clarifies, there is a certificate of service, which checks all legal boxes. You can almost feel her frustration rising, but the courtroom isn't here for confusion, it's here for facts. This exchange perfectly illustrates why attention to detail is everything in legal battles. The law is precise, and attempting to bend it without evidence or correct procedure is a fast track to embarrassment. For the audience, notice how even small missteps in terminology can become massive sticking points in court. Legal precision matters.
Yes, it is correct. Because if you received any type of funds from HUD, which is through Section 8 vouchers or regular vouchers, you get what I'm saying? You receive funding from HUD.
We are. Do you?
I'm not saying that you're funded and that they give you loans of that nature. I am saying that you are within their practice and policies of HUD guidelines because you accept HUD in Section 8.
Your Honor, I object to this whole line of questioning. Miss Battle does not receive a voucher, and so all of this questioning.
Well, it doesn't matter if I receive a voucher. It matters that you are of that type of entity that needs to go through HUD because you accept those things. So
Your
you
Honor,
agree with those terms and policies of HUD.
Your Honor, she's making that up again.
I'm not making that up. If you're saying that how am I making it up? It's under 42 USC 1437 DK.
Battle.
It's a
Ms.
federal
Battle.
registrar on it.
Ms. Battle, you've made your record. My ruling is still that every entity that has to file a landlord-tenant action does not have to go through the
Gets even stranger. Miss Battle asks about HUD grievance procedures. Random? Absolutely. Relevant? Not in the slightest. The lawyer objects, citing irrelevance, and the judge clearly isn't impressed. This is a prime example of when a defendant's attempt to inject unrelated issues just makes their argument weaker. Watching this, you can't help but feel the tension between procedural correctness and someone trying to improvise their way through a courtroom. Audience engagement moment. If you were the judge, how would you handle a defendant going off script like